All right, investors, let me come to the stage. Let me come to the stage. Let me come to the stage. Come on, come on, come on. We're gonna continue to go ahead and talk about this Karmelo Anthony case. Like I said, today is 34. Today is 34. And for everybody that has been supporting the videos, thank you so much. As I stated in the last live, I did my homework and I got the information, and we about to go ahead and knock it out so I can let you go. I know I say it all the time. The slides is still loading. The slides is still loading. So while they are loading, let me go ahead and go to the comments. Let me go to the comments and say, welcome, Vesters. Welcome to Tony Talks Vested Up Compelling Sports Edge. And while the slides are loading, make sure you go ahead and get your notes, your drink, and your vest, because we vested up over here 365 degrees at Tony Talks Vested Up Compelling Sports Edge. Let's see here. Hey, what's up? Wayne Williams 3916. Thank you so much for becoming a member. I think that was this morning or yesterday. Thank you so much. Thank you so much. Them slides are ready. Here we go. Here we go. What's up? Here we go, buddy. What's going on? Bright evening, Tony. Let me be the first to join you in the upcoming live and chat. Mr. Wayne Williams beat you, but I'm gonna about say for about 7 hours, but you are the first one after him. Lady of Elegance, what's going on, Lady E? What's up? Hello, Tony investors. Let's get it on. Go ahead and get your notes. Go ahead and get your notes. So what's up, Patrice? How you doing? Good evening, Queen, and all that love and butterflies and everything. What's up, Justine? Come on with it. What's up? What's up, Trisha? Tennille. What's going on? Hey, how you doing? How you doing? How you doing? Who is this right here? Tisha Harris. Hey, how you doing? Hey, how there, Tony Talks and Chat? Tony Talks and Chat. What's up, baby boo? How you doing? How you doing? You know I enjoy you in the lives, in the chats, and everything else. What's up, Red B458? How you doing? How you doing? And what's up, Mel? What's going on, Mel? I see you here. I see you here. Now let me go ahead and put these slides up. Let me go ahead and put these slides up because I got something for you. I know that's not the first one. Don't do this. Here we go. I got to say thank you so much. Those glasses have come out in about 3 minutes. Thank y'all so much for the awesome live that we had Saturday night and we went into Sunday morning. That was an awesome 3-hour live. We talked about so much and the energy was so live and the support. And I just want to say thank you to everybody because that live was good, okay? That live is good. Y'all drained me so much, I had to take a break yesterday. That's why I'm back today full of energy and I'm ready to talk to the investors because I got some good information from you. I got some information for you from 2 lawyers that we haven't seen before and 2 Black women. One is actually a court reporter. Now, some of the information, I understand what you said. It's a lot of information that we agree with, but there is one piece of information that I didn't know. I thought the taxpayers pay for the fee, but we're going to get into this. And I had a special request for one investor. They said, Tony Talks Vested Up. You need to go to Wikipedia and see exactly how they wrote up the case regarding Karmelo Anthony and Austin Metcaff. So guess what? I'm going to oblige that investor. And y'all, whoever put this in Wikipedia, you might as well say they was part of the collusion too, the way they wrote this up. Hold on, let me go and put everything on silent. Everything on silent. Hold on. I ain't going to keep you long, but I'm going to keep you right. Come on with it. Here we go. I'm here. What's up, Wonder? How you doing, Wonder? I got your beautiful message. Thank you. What's up, SDP 1208? Red Hey Mars in chat. What's up, Tessa? Miss Sassy Pat. Miss Sassy Pat, I like that name. How you doing? Bless. Hey, what's going on? There's a mile. Brooks, hey, how you doing? That's my first time seeing you here. Oh, there go that Slim 081. I ain't forgot about you in the Carolina Panthers. We're gonna eat you. Wait, I'm here, Tony. Hello, investors. I've been waiting to be in this safe place with my peeps. Come on with it. Shout out to Miss Tony. Shout out to the not guilty. You know who I'm about to talk to. Come out with that no guilty boys. Come on, Mike. Listen, let me tell you one thing, Bunny. I don't know who you are, but stop hacking into my computers and knowing exactly what I'm going to talk about on that particular night, okay? Shout out to you, Tony. Shout out to the no guilty boys. Come on, Mike. File that grievance to go with your affidavit. Thank you, supporting. God darn it. Okay, let me go and tell you. So one of the no guilty boys, right? They said, basically, I was gonna bring this up later, but I'm gonna say it now. They basically said, well, at least let me go ahead and pull up their pictures, because I had them ready. Let me just go ahead. Miss Bunny came in here and threw the whole timeline off already on this good. Let me go ahead while the room is still. I want to go ahead and address this. Boy, Bunny just threw out my whole timeline. Here we go. God, I might as well start with them. Let me go ahead and start with them. Let me go ahead and finish with the chat. Then I'm coming back to you, Bunny. But I just said I don't forget. One of them said that, like I said, the only reason we got here, and for sure, that Judge Roach will be recused and that this will be a new trial and the appeal will be get granted is because Mike Howard gave up the gusto. And so I'm listening. I think it was last night. It was a 36-minute video, right? And then they channel was up there, I think it is. So one of them said, hey, you know what? We are surprised that Karmelo Anthony new legal team did not say one of the grounds for the appeal was ineffective defense of counsel, right? Ineffective assistant of counsel. And both of them say, yeah, I agree. But you know what they did say? They say, well, you know what? The legal team, and I'm pretty sure Mike Howard has agreed to this. Mike Howard is basically going to be that Trojan horse that the opposition, the prosecutor, and Judge Roach didn't see. I'm going to label him as a Trojan horse that they didn't see coming. Basically, they're going to use Mike Howard as a very critical part of the appeal process on why Judge Roach will get accused and while we get a new motion for a new trial. So basically, Mike Howard is basically part of Carmelo's Anthony defense team, sort of in a way, because he is the most critical piece in order for this case to move forward. So they didn't bring up the ineffective counsel because Mike Howard is basically playing now on the side of the new legal team. If you don't believe me, here you go. Let me go ahead and play it right now. I'll let you hear it from out of their own mouth. Only got two clips. So we're going to move forward. We're going to move forward. And this is what they said. And I can see it. I can see it because basically Mike Howard is a piece that they didn't see coming. And if that affidavit, let me tell you one thing, that affidavit, if you go through all the exhibits, that is one of the most damaging pieces in that whole entire appeal packet. So just imagine if Mike Howard was just like a Toby Shook or the prosecutor who hasn't given up their affidavits, we still would be definitely still feeling positive about the recusal and the motion for a new trial. But with this affidavit, like I said in the last live, who needs a rigged transcript when you got an affidavit from his legal attorney? I'll take that. Here we go. Come on, gentlemen. Now listen, they was hot and raw, okay? They was hot and raw, so it's for some profanity in here. A warning. Okay, come on, brothers.
You piggyback on something you said. First and foremost, God is my witness. Strike me down if I'm lying, bro. I don't even get. That's what I'm saying. Like, you know, and it goes back to not hiring a black attorney. Hire whoever gonna help you the most. But you went and thought you had a good old boy, and you did. You had a good old boy and sold him right on up the road. Because see, look, if he was actually prepared and had his client ready to testify no matter what, it wouldn't have mattered if that gentleman's agreement went out the door. He'd have been ready.
Right.
And he'd have been ready. About that agreement, I heard the judge say this. I don't have no way to enforce that agreement. And even though nobody may like it, the judge might be right. Well, how does he enforce that agreement? It ain't
he could have put it on the record.
That's why it needs to be right.
He should have put it on the record.
That's why it needs to be on the record. Call the court report.
You know what the record is? The record is that docket. It only got about maybe 1 more minute.
And all the people got them nice ass offices in the back. Call them in, say what the agreement is, say that both sides agree, and be done with it. Bro, gentleman's agreement, and a nigga life on the line. That's how you know, bro.
It's two ways. There's 2 ways you could have locked it in. You lock it in a motion to eliminate, right? Agreed motion to eliminate. You lock it in a stipulation, evidence. That's how you lock it in. But Mike, you just don't trust Bill because you have cocktails with him every other Friday at the golf course. You can't trust.
Listen. If y'all don't remember, the reason why Mike Howard trusted and even went this direction with Bill Whiskey and Greg Willis, because I told you, rumors came out that Mike Howard knew Bill and Greg from years ago. I think it even came out that, was it Bill or was it Greg Willis that was Mike Howard teacher in college or some type of counselor in college? So this is why Mike Howard, and now while he's rolling over, maybe his ego is bruised, but let me go ahead and finish playing this about 30 more seconds.
Bill knew that you was
that motherfucker look shaky. He look untrustworthy, bro.
But all that you heard is live, being live in this video right here, everything is about to get scrapped because I know YouTube is not going to allow that over here, but I didn't even capture that piece. But another reason why I think Mike Howard rolled over onto Bill and Greg, even knowing them, is because I think a big gun called Mike Howard and say, hey, they coming for your license. They coming for your legal license. You're about to get disbarred and you're going to get hit with a federal civil lawsuit and federal charges. So, hey, he's going to roll over on his friends. That's the only thing that I think convinced Mike Howard to roll over and play dead. And tail on his buddies. But let me go ahead. Let me see here. Why do you think the transcripts still see? Well, here we go, Bunny. Didn't I tell you, Bunny, you gotta stay out of my computer? Bunny, you gotta stay out of my slide deck. Well, let me go ahead and play this right here. I guess I'm gonna go ahead and just go ahead and play all of my audio clips in the beginning. Just here. Let me go ahead and put this up. Well, I got 2 sisters here. And the one, it was the black blazer. She's actually a court recorder, right? So, Bunny, I'm been in my slides. Let me go ahead and play this. I only got 2 clips. Once again, 2 clips.
Yes, I was a public defender when I first started in Fulton County, and that was 2006 to 2014. And that's where I know Ms. Hill from. So that's our connection there. All right. So as I stated in my opening, kind of just going through the things that were jaw-dropping to me. Have you ever seen a case where, we're over a month now after the...
And to answer your question, Bunny, why do I think the transcripts are still sealed or the public no, the transcripts are still sealed. And one of these ladies here in the black blazer, basically she said that the court reporter has not even started on the transcripts. If she has, they're in early development. But the case files itself is totally different. The case files is sitting in Judge Roach's office under lock and key. Hold on.
The verdict has been rendered and the file is under seal in the judge's chambers and nothing's on the public document.
Yes. So the short answer, which we as court reporters really like, is no. There has never been a case that I have personally been a part of that the entire record is sealed from the public, from even the attorneys. that is totally unheard of, that are done in camera, even ex parte. But even those are reported by the court reporter because it is a part of the record. It may be sealed, that portion, but when you say an entire trial, no.
You also heard me mention that in this case, there were documents that were hand-delivered. They were not e-filed, so they weren't made part of the public docket. And the hearing for those motions were actually in the judge's chambers. Now, have you ever been a part of those before as a court reporter? Have you been in chambers when there have been secret hearings?
So, yes. Now, secret hearings, it is not secret type thing. But now there have been situations where I have been a part of an in-camera hearing, produced a transcript from it, hand delivered it to the clerk's office because it is sealed and it has to be open under the order of the court. But again, for an entire trial, no. An entire trial is a public record. The public is entitled to attend a trial, be, able to view all proceedings. So for a trial transcript to be sealed totally is very unusual, very out of the norm. When I was in Fulton County, I worked for a judge in Superior Court. That judge had a saying out loud on the record, meaning that she would never conduct a hearing outside of the presence of the defendant, outside of the presence of the prosecutor or the plaintiff, outside of the presence of the defense attorney.
Yes, because you're creating a record because something's done in your, like, say, Superior Court, and I want to appeal it. In order to take it up to the appeals court, I need to produce the transcripts in the record. And I wanted to go back and clarify. You said the transcripts are under seal. Get this, the transcripts haven't even been started. The court reporters have not started transcribing this case.
Y'all hear this?
So it's just the docket in the sense of whatever motions the parties filed, whatever the judge's rulings were. Those are the things that are sitting in his chambers because the transcript has not a day of this trial, not jury selection, not any of the motion hearing. Anything has been transcribed to date. Is that normal? Have you ever seen that?
Listen.
Okay, so let me just touch on that. I saw a comment on social media, so I do want to address that part.
Listen.
Transcript production is not free, okay? There's a cost associated with producing a transcript. As a court reporter, we are there at the behest of the court, at the pleasure of the court. We are there when the court says, I need a record. So my position, I show up to make that record.
Now, I know y'all shocked. I'm shocked too. I thought if a case is going through proceedings, I thought the transcripts are drafted because it is a court proceedings. And I thought that the court reporter is paid by the county. I'm learning that you have to pay for the court reporter to draft a transcript. I never heard that before. Please, if y'all have heard that before, please let me know. Please let me know. I'm going to go ahead and finish playing this. For this particular clip, only 1 minute and 40 seconds left.
Whenever that record has to be produced. That record is produced on my personal time. So therefore, I have to be paid for my services. I am bound to the court during court hours, Monday through Friday, 9 to 5. Transcripts are produced by a court reporter outside of those times. And therefore, that court reporter has to be paid for his or her time. So to come back to your question about the transcript being produced, and that post that I saw, the transcript costs tens of thousands of dollars, whatever the dollar amount is. That has to be taken care of before that court reporter begins production on it, because the court reporter is not just a person, but we are also a business. So therefore, we employ people. Those people have to be paid. So that's the answer to your question. So But the transcript has not been produced. Either they have not officially ordered and paid the court reporter to do it, or because of the circumstances going on, the judge has probably ordered the court reporter, don't produce that transcript.
Yeah, that's
so
what
it could be one of those two things.
Because the case file is still under seal, and he would have produced it to the actual appeal attorneys, the attorneys that have filed an entry of appearance and are representing Karmelo, did not get the file or the transcript. They wanted the transcript before. They wanted the transcript in the motion for new trial, because that's how you can find each and every error. They weren't able to do that because the judge is not allowing it to be produced. He is keeping this file under seal. So that's just not normal. And so we spoke about in camera, and I want to explain to the channel what that is. So in camera usually.
So I cut it off for that. So as we found out, a court reporter, that is a separate, how can I say, a fee. So if that's the case, what is the duty of a court reporter if they don't have to produce the transcript? Now the case file is separate. Now to me it seemed like the new legal team knew this, which is why they were going after the case file. Now I did shout out to a legal doc talk. She gave 5 different scenarios on how the new legal team has to go through several different processes to even get the case filed. And I'm like, what? But hold on. So Judge Roach knew exactly what he was doing. Now, let me go and play this one more thing right here. And it's from the sisters again.
In ahead out the box. In this case, with the transcript, it's going to have to eventually be produced because Mr. Anthony is part of his appellate rights. The transcript has to go up. My thinking is this judge is probably going to be recused, and then the next judge sitting on the case will then open the record.
Yeah, I agree. And we're going to talk about this live about the motion to recuse and kind of why it's really favorable in this case to be heard. So before I let you go, because I know you got to go.
Yes.
One more question. Talk about, like, there have been cases, kind of like the Diddy case, right? Of whatever hearings or whatever was happening daily. And so, do you see that in trials? And what's the typical time frame after? I know you said first y'all got paid. Let's say I ordered the transcript the day the trial ended. What's the typical timeline that I could expect that trial transcript to be ready?
Oh, okay. So it just depends really on what court you're dealing with. Court reporters are employed in lower courts all the way to federal court to the congressional floor. Right now, for us, transcript production can be anywhere from immediate to 30 days. So sitting here in the federal judiciary, I do daily copy high profile trials almost every month or so.
Daily copy is meaning that you're producing the transcript every day.
Yes. So I offer real time. So what I do is I connect the attorneys to my iPad, and they can be in the room in any part of the world. I offer them a real time production, and they get the proceedings as they're happening in a rough format. And then after that, I go home, produce this transcript with the help of what I call my steno L's. That's another conversation for another day. But my steno L's sit in the background somewhere in the world.
So she just going on to describe how different ways that these court reporters do transcripts. Let me go to the comments here, because I really got perturbed. When I heard this information right here. It's all love. No. Hey, Bunny, that was a joke, sweetie. Sweetie, that was a joke. I like her too. She will inform you how court reporters operate. Gotcha. Hello, everybody. I'm VestedUp. I enjoy your content and a blessed one. What's up, Shirley? I remember you. Okay, Lakeisha Such stated that KA attorney have to go to the judge chambers to see the file. And listen, I heard that Judge Roach, he agreed to let the new legal team go to his chambers to see the file, but they had to agree to not share with anybody on what they saw. I said, what kind of mess with that? Who is Judge Roach? Yo, let me re-say it again. Told Karmelo's Anthony new legal team in order for them to see the case files. He agreed to let them see the case files, but they had to agree to not tell anybody on what they saw. Who does Judge Roach think he is? Now, going back to the legal doc talk, this is what I recorded, and this is what she said, the different ways in order for Karmelo's Anthony team to get the case file. We're not talking about the transcript, the case file. So basically he's sitting on it. And let me go right here. Where are my notes? Here you go. And this is in short order, okay? Judge Karmelo's Anthony new team must show proof that it was requested and denied by Judge Roach. And then they have to file a new motion to get the files unsealed through a certificate of counsel, right? So that was Exhibit 11. And then once the new motion is filed, it has to go, then it must go to the Fifth Court, which is the right of mandamus, right? Basically saying that Judge Roach didn't do what he was legally responsible to do, which is turn over the case file, and then the Fifth Court, contact John Roach and make him do exactly what he needs to do legally. Be to go directly to the district clerk, who is the official custodian of the case files, right? So there we go. And I'm like, yeah, I don't know what direction his new legal team is going to do, but Judge Roach is going to throw up so many challenges, but I'm pretty sure this legal team is very equipped and knowledgeable of what needs to happen. And so as of right now, it seems like we got good grounds for an appeal. I'm pretty sure they definitely need the case file, right? And they only got a certain amount of time. So I'm pretty sure they're expediting a lot behind the scenes. And I'm pretty sure they know of a lot of avenues. So right now we're just in a wait and see what's going to happen. But I think that it should be other courses of action that hopefully we can get something done in about 2 to 3 weeks before the time expires. But Judge Roach, he has to turn over the case files, okay? He has to turn over the case files. I don't think nobody would ever know Kamelo around the United States if they would have had done right in the first place. I agree with that. Let's see here. Case files locked up in Judge Roach chambers. Thank you to Tony and court let's see here. Don't worry, Kamelo, your internet uncles, aunties, grandfathers, cousins got you. Yes. Really, I never heard of that. Me either. I thought so too, Tony. If appeals, right, and this is an appeal, so somebody got to move in. Now, I think once it goes to the higher judge, the regional judge, the intermediate Texas Court of Appeals, I think they have the power. So they don't have to go through none of those other options I told you about and just discussed. They should be able to contact Judge Roach and say, hey, this is your deadline to release those case files to me. I think another judge, especially at a higher level, should be able to reach down and demand Judge Roach to send those files up without even the lawyers getting involved, because even the new judge has a time frame to look at the appeal, review everything in the appeal docket, and render a judgment, granted or denied. And he's gonna need that case file. So I think the lawyers don't even have to go there. they can just submit, at least show that they have requested the case files and provide information and proof that Judge Roach has said no, and move forward and let the regional judge do all that. We don't got time for this. We don't got time for this. Lady E, it was said the lawyer could review the transcript, could be viewed. Right, I just said that's right, Justine. Come on with that alley hoop. Roach knew this case would be appealed. Roach is of the old school practice. If there ain't no paper, it's vapor. Hold on, who said this? Hold on. Who said this? You're Sanders. Tessie Sanders. He knows that the delay in composing the transcript must happen. Roach stalling justice. Well, he can only stall justice for so long. When that appeal packet goes up, now that since he has denied it so quickly, so let's go ahead and address Judge Roach ego and his pride. Now, John Roach, he ain't even thinking. John Roach had 75 days to sit on the request for a recusal and a new trial. John Roach, he sit on that paperwork for about 3 to 4 days, denied it. He thought it was a slap in the defense case, face and right. He thought it was a slap in the new defense face and their case. But really, he only took 24, 48, 72 hours to deny it. That means now the paperwork didn't have to wait for the full 75 days. It actually accelerated to the second court already because John Roach ain't thinking. He actually accelerated it. So yes, John Roach, he is, how can I say it, putting roadblocks regarding some things, but he don't know he has actually accelerated the case because he only took 2 to 3 to 4 days just to review it. He probably never. Let me tell you one thing. I'm sorry, y'all. It just came to me. If John Roach only took 1, 2, or 3 days to deny the retrial and the appeal and the recusal, that means John Roach never even took time to see Exhibit 10. Do y'all hear what I'm saying? If Judge Roach, he didn't even take 75 days just to sit on it. Now that definitely would be hurting the timeline. But he only took 24 to 48, 72 hours, maybe 96 hours to deny that. That means that the process is actually moving forward to the second court in Texas of the appeal process. So John, he got an ego, but he's stupid too at the same time. But I wonder, did he know that Exhibit 10 was in there? I wonder if he knew that Mike Howard's affidavit was Exhibit 10. And they said that black people don't read. I don't think Judge Roach even read Karmelo Anthony appeal packet and looked at all the exhibits and looked at all the y'all. Trust me. Pride comes before the fall. Any and everything that judge can do, he's doing, but he's hateful. Listen, Pam, I would be more worried if John Roach would have sat on that whole entire packet, because remember, he had 75 days to address it. John Roach, he saw that thing signed off and sent it on signed and sealed and delivered. He didn't know that he actually accelerated the packet to go to the second level. I'm trying to tell you. He's trying to be hateful, but he's actually accelerating the packet. John Carl Roach doing the most. If he can, I believe he will appoint another judge like him. He can't. He can't. He don't have the power. He don't have the power. And I put it in somebody's comment under the last video, right? I said if the second judge gets Karmelo's Anthony packet and actually look at Exhibit 10 and they still refuse a new trial and a new judge, that's how deep we know that the corruption is in Texas. Well, Tony Talks Vested Up, what did you say? I said if the new judge on the regional level, which comes out of the Fifth Court of Texas, the Fifth Appellate Court in Texas, if he or she get that packet and they rejected, even with Exhibit 10 being in there, we'll know how deep this corruption is. But don't panic, because still, I had already covered all of the other steps that the packet must get to. And once it go to federal, it's over, y'all. It's over. So here we go. When I think about it, it's how they've been operating the whole time, backdoor deals, made up agreements, and basically whatever they want to do, devils. Facts. Warning, Jesus is coming. You saved? Are you saved? Have you been born again? Thank you so much for that, Clara. I know, Tony, it was a joke. Let me see here. Come on, StreamYard. I was just being appreciative to be a part of your. Come on, you good. You good, buddy. They need to hold a roach in contempt. Let me tell you one thing. Oh, listen, I got another Vestal. That be in my line of homework research. Let me go ahead and show you this. Now, I discussed the punishments for Mike Howard and the prosecution, right, on that illegal deed. I was going to bring back, right, the punishment for the judge that was part of such illegal deals. Now, okay, we already got the brothers out the way. Here's, okay, sisters out the way. Here it go. What is a judge punishment for participating in an illegal lawful agreement, right? Because we know in the affidavit, and they say black people don't read. We read all 30 paragraphs of Mike Howard's affidavit, Exhibit 10. Now, also in that, Mike Howard said that Judge Roach got a copy of the agreement in hand. So that means that Judge Roach, he knew about it. Even though he didn't put it on the docket, he knew about it, right? If a judge were ever proven to be knowingly participate, if a judge was proven to have knowingly participated in an unlawful agreement, the circumstances could be among the most severe in the legal profession. The specific outcome depends on the facts, the applicable law, and whether the conduct violated ethical rules, criminal law, or both. We already know this based on Mike Howard's affidavit, and it was executed. We know it does. So possible consequences include removal from office. Here we go. In Texas, judges can be publicly censored, suspended, or removed from office through the state's judicial discipline process. Very serious misconduct may also lead to impeachment or removal under other constitutional procedures. Number 2, judicial discipline. The State Commission on Judicial Conduct can investigate complaints against Texas judges. Possible sanctions include private warnings, public reprimand or censure, suspension, and recommendations for removal. Let's keep going. Hold on. Let's see. The next slide is criminal prosecution. Judges are not immune. Hold this, y'all. Go ahead and get your notes. Hold on. Judges are not immune. Let's see here. Wow. My slide. Hold on. Let's see here. Criminal prosecution. Judges are not immune from criminal liability from crimes they commit. If a judge knowingly engage in conduct such as bribery, obstruction of justice, conspiracy, evidence tampering, the video, honest service fraud, in applicable federal cases, derive a constitutional rights on the color of law in some circumstances, they could face criminal charges. Convictions can result in fines, probation, imprisonment, depending on the offense. Let me start right there. So Judge Roach, we already knew this. Judge Roach knew it. Roach knew exactly what he did in this case. That's why he went on ahead and did the interview. And that's why shortly after the interview, he said that he was going to retire in December. Well, it don't matter if he retires. it don't matter if he's still on the bench, because federal charges are coming down. So even if Judge Roach, let's say he retires and he think that he's untouchable, listen, that's going to make it even better than Judge Roach being retired and somebody knocking on his door and putting him in handcuffs. Let me say that one more thing. It's going to look even better when he's retired, thinking he's about to just enjoy life, travel like he want to travel, do the things that he want to do. When his freedom is taken away in his retirement, that's going to be bittersweet for, ooh, I'm going to love that. I'm going to love that. Now, it also includes loss of judicial office and retirement benefits. Uh-oh, Tony, what you said is loss of judicial office and retirement benefits. Let's take a moment of silence. Let's take a moment of silence. Depending on the governing law and circumstances, a judge found guilty of serious misconduct may lose judicial office, which he's already trying to walk away in December, and could also face his consequences affecting retirement or pension benefits. Listen, I don't need to say nothing else, y'all. I don't need to say anything else. Let him go ahead and retire. That's why I say it's going to be even better. It's going to be even better if he retire. If he retire, because he's going to lose his freedom and lose that retirement pension that he thinks he's going to get. That's John Roach. Retire. Yes. After he did that interview with WFAA, he said shortly after that he was going to retire. Judge Roach would have to live off those books. Well, if he's behind bars, I guess the money can go on his books. Nah, them take them benefits. Nah, not the. Nah, them take them benefits. Nah, not that one. He got friends in high places. Retirement from the bench doesn't remove Roach. Right. That's what I'm saying. He can run if he want to. Did you hear? Yes. And I played that already, Egyptian. I played that. Them boys was hot. That first 15 minutes, I may have to remove that after YouTube finished processing that video, because we signed. I'm just saying, them boys was raw. There's a hero bayou and Point Clear Drive, swimming pools, and accessible docks from the bay. Let's see, how many times has this judge and prosecution in Karmelo's case done a gentleman's agreement? I'm pretty sure that so dumb right now, stupid, but thank you. Oh gosh, already. They listen, these people funny. He is lying. I'm kind of that kid arguing about his girlfriend is lying, kind of. They can still add effect. Right, they can, Katie. They can. Blessings, everyone. Hey, how you doing? Oh, what's up? How you doing? Love you, Tony. Keep up the good work. Good approach. 2 years. He's free. Thanks to love and skill in the Most High. I don't think he's going to be for 2 years. Peace, blessings, and black power from OKC. Come on with it. Karmelo Anthony is anointed. Yes. Let's see here. The Most High is disposing him, making react in this case. The year of the Most High God revealing. We must start keeping the people together going forward. Yes. Let's see here. Lady E said, Justine, you are right. I did not listen to the entire show. Just the beginning of about 2 minutes. Did anyone really think Judge Roach will recuse himself? Nope. He said, I'm going to be in a struggle until I retire. He can. Come on with it. But he celebrated that case, Carmelo's Anthony Packett, to the second. He didn't even think about that. I really thought that Judge Cockroach was going to sit on it for an entire 75 days, because that would have put us in at the end of August or the beginning of September. And then let's just say the next court will have to take another 45 days or 90 days. See, that would have been at around about the end of John Cockroach's retirement. But based on what you see, even if he retired, he could lose his retirement and pension when those federal criminal prosecution cases come down that has the state of Texas versus John D. Roach, if that's his middle initial. Let's see here. Now we really need to see unredacted video to see. Come on with it. Come on with it. Come on with it. Hey, Tone. What's going on? God is working. Let's see here. Of all the cops show I've seen, I don't remember ever. I know anything about transcripts. I know this being paid for. I know this. So my thing is, so if they're not doing the transcripts, what are they doing in court? Like, for real, this is a serious question. So if a court reporter is not drafting or not taking notes or not recording what is said in court to produce the transcripts, so what are they doing, and why are they not getting paid by the taxes, the county taxes, to do their job? Because the judge, I'm pretty sure he's getting paid by the taxes, right? County taxes. So I'm confused. Roach may become no. I don't even want him to touch my receipt. Come on with it. I hope he loses all his benefits. You see it on the screen. They have done this to other people. What are the chances that Hunter still lied? A lot. According to legal docs, she stated that the file in the judge's chamber seal, right. And that's what the other two ladies said. In an ideal world, Judge Cottrell and prosecutor would have changed places with Kamelo. Just wait and see. Give it time, buddy. Roaches know how to survive. Give it time, buddy. He sure did have a victory lap. Come on. Hey, how you doing, Sandra? He needs to, Judge said, force. He needs to run that victory like on back. Come on with it. Okay. Now, let me go ahead in order. Since I had a Vesta want me to go, she said, ToneyTalksVestedUp, you got to go out and see what Wikipedia has reported on this case. I said, well, okay, I will do it. Let's see what, if anybody didn't know nothing about this case, and now we know for sure that there is a lot of people that don't even know about the packet that was dropped last Wednesday and Mike Howard confessions. I'm going to call it Mike Howard confessions in Exhibit 10. So let's see together. I read a little bit of it, but I didn't go in detail, and I'm not going to really read all of it. But for all of the people across the world, if they don't have access to our channels, but let's just say if they Googled this, let's just see what is being publicized to the world. And we already know that once Karmelo is exonerated, all this right here will change. And I read some statements in here. I'm like, oh my gosh, they must have had to been Metcaffs. Now, here we go. Here we go. On April the 2nd, 2025, Austin Metcaff, a 17-year-old student. Hold on. A 17-year-old student at Memorial High School was murdered by Karmelo Anthony, a Centennial High School student of the same age while attending a school track meet in Frisco, Texas, United States, right? Anthony stabbed Metcaff after an altercation, and Metcaff died of his injuries. Hold on. Injuries? Let me keep pushing, but you see why I say injuries. Anthony was arrested soon after stabbing and charged with the N-word. He pled not guilty, asserting self-defense. On June the 9th, 2026, Anthony was found guilty at trial and sentenced to 35 years in prison by a jury. The case was subjected to national public attention, and viral social media posts emphasized the race of the perpetrator. hold on. The perpetrator who was black and the victim who was white background. So let's keep going. Let's keep going to the next one. I want to see what they got to say up in here. So Austin Metcaff, he was a VIP linebacker of a school football team and participated in track and field. He had a twin brother, Hunter Metcaff, who also played football. Now, let's go to, that means Hunter would have had a birthday at the end of the month. Let's see what kind of shenanigans the Metcaff is going to do at the end of this month. But you know they've been quiet. You know the Metcaff's been quiet since the appeal, the new legal team and the appeal process moving forward. And Mike Howard's affidavit. Let's keep going. Now, Karmelo Anthony. Let's see what Wikipedia has to say about this. Born in Baton Rouge, Louisiana, the Texas later moved to Texas. Let's see here. Was a student at Centennial High School, where he was the captain of both the track and football teams. He had two part-time jobs, and at the time of the incidents was on track to graduate the following month. He has no prior criminal history, and Anthony and Metcaff did not know each other. So how was it premeditated murder if they didn't know each other? Premeditated murder means that I know somebody, and I know you're going to be here at such and such date, and that's going to be my opportunity to inflict any harm to your body. But hey, okay, Collins County don't have any common sense, but let's keep going. Let's keep going. Now let's see what else Wikipedia says about this case. Because the investor reached out and said, Tony, you got to see exactly what Wikipedia said about this case. Okay, let's see here. The incident. The stabbing occurred at a track meet at Memorial High School at the schoolhouse at the stadium at 10 a.m. The altercation started when the track and field championship event was delayed due to thunderstorm and downpours. Everything so far, I can see. Besides the injuries, I can see. Let's see here. Okay, during the rain, every team except Karmelo's Anthony's high school set up a tent. One of Anthony's teammates testified that he and Anthony and other team members had sought shelter from the rain at a nearby baseball dugout until a baseball coach told them to leave. Okay, according to the witness testimony, Anthony was called over to Memorial High School tent by Memorial student Eddie Parra. Okay, Wikipedia. Parra and Anthony had a friendly interaction for about 5 minutes. Let's keep going. Okay, let's keep going. Let's see what else Wikipedia got to say about this case. Let's see. Hunter Metcaff, Austin's twin brother, approached Anthony and asked him to leave the tent. Even Wikipedia is saying that the Metcaff, at least one of the Metcaff brothers, was the first aggressor. Okay, same as Mike Howard. He said, now, according to Mike Howard's affidavit, it was Austin that the prosecutor knew was the primary aggressor. If you don't believe me, I'll pull it up, okay? Let's keep going. Austin then confronted Kamelo. True. During the argument that ensued, Anthony allegedly says, touch me and see what's happened. We saw that in the arrest record. While reaching his hands into his book bag, total lie, because we already told that up. We already talked about that. According to witnesses, Metcaff respond, you don't have anything in your book bag, it's Frisco, before allegedly grabbing Anthony to move him. That part is true. One witness quoted Metcaff as telling Anthony, I'm not going to fight you at the track meet. That's a lie. Another witness in Frisco police record stated that Austin and Anthony went back and forth, and then Austin stood up and pushed Anthony to get him out of the tent. In response, Anthony pulled out a black knife from the book bag. Now y'all know that's a lie, because Hunter said that him and Austin, one of them took Karmelo's Anthony book bag away from him. So, okay. So we start to see some inconsistencies even with what Hunter said. Instead, Metcaff once in the chest before running away. Let's see here. Let's see here. Here we go. Okay. After being stabbed, Metcalf run down the bleachers, grabbing his chest and telling those around him to get help. Now, y'all know that didn't happen. Y'all know that didn't happen. When the police arrived, he was not unconscious. He was not unconscious or breathing, and athletic trainers were performing chest compressions on him. Oh, he was not conscious or breathing, right? That's facts. And athletic trainers were performing chest compressions on him. Austin Metcalf was pronounced, no, he wasn't. No, he wasn't, because we saw what the officers put in the arrest record. He passed away shortly after arriving at the hospital. The same thing his mother said. Here we go. Keep going. According to the arrest record, when told to keep his hands in the air, Anthony said, "I was protecting myself." The affidavit stated that he was emotional and crying hysterical after his arrest. I didn't hear that, even though they cut that out of the arrest body cam. The officer then communicated to others that he had the alleged suspect in custody, to which Anthony responded, "I'm not alleged, I did it." We already talked about that. They spliced the video for him to say that. They spliced the video. Okay, but his arguments about that, okay. As he'd been escorted to the police car, Anthony reported said, "He put his hands on me. I told him not to." Facts. While he was sitting in the back of the police car, he asked of Metcalf, "Is he going to be okay?" and asked the officer if what he did would be considered self-defense. I didn't hear that. The aftermath. The courts approved Anthony moving to an undisclosed location due to safety concerns in the pre-trial period. According to the Next Generation Action Network, NGAN, a nonprofit organization working with Anthony's family, the move was participated by an alarming increase of death threats, continued harassment, and physical intimidation targeted at him and his family. All right, let's keep going. Let's keep going. Let's see what else it does say. Legal proceedings. Now, yeah, that was it. Anthony was charged with murder and transported to Collins County Jail. He was charged as an adult since under the Texas criminal justice system, defendants aged 17 and older are prosecuted as adults. Okay. This is the first judge. On April the 14th, 2025, Judge Angela Tucker lowered Anthony bond from $1 million to $250,000, citing his clean criminal record and his academic and athletic achievements. Okay. Anthony was released on bond the same day. Okay. According to his release conditions, an adult was required to supervise Anthony at all times. He was required to contact the judge, bailiff every Friday morning, and he was prohibited from using social media or contacting Metcaff family. Anthony's lawyer said that he would plead not guilty and claim self-defense at his future trial. Anthony could not have been subject to sentence of life or parole or the death penalty due to his age. On June the 24th, 2025, a grand jury indicted Anthony on charges of murder. And we went over this. This is called the pre-trial phase. When Mike Howard, now mind you, they didn't have a gentleman's agreement on this date here, on June the 24th, 2025. So at this stage, that's when the prosecutor is supposed to turn over all the evidence for the Brady disclosure, right? We went over that. He's supposed to turn over all the evidence to Mike Howard, and in return, Mike Howard at this time could have objected to anything. Now, Mike Howard, even at the beginning, you had power that you did not use in the pre-trial process, phase 3 of a criminal trial. Mike Howard could have objected to the video, the lack of evidence, anything. He could have even put up a fight at this particular phase to even get the case thrown out. So why this even went to trial, we don't know. So Mike Howard, I have to ask you, why didn't you fight at phase 3 of a criminal trial to even stop this case from going to trial? When he showed you that grainy video, if, because John Roach said it took 8 months to do all the IT work, behind the scenes, the audio, the visual. Did he even know of a video at that time? Mike Howard, let me tell you one thing. Let's say a video wasn't produced at that time. Mike Howard could have definitely got this case thrown out, because if you didn't have any video at that time, he could have said, where's the proof that my client did it, right? Now, let's just say Mike Howard had that crystal clear video. Why did you even let this go to trial? These are serious questions that I still got to ask for Mike Howard. First of all, what was the damaging evidence that you felt like tied Karmelo Anthony to a worse punishment if it came out in court? And then second, why did you even do this agreement? And third, what did DA Greg Willis and Bill Whiskey have on you to even agree to this? But that's, look, only Mike Howard can answer those questions. But let's just keep reading. But those are just my thoughts. Let's keep going. Those are my thoughts regarding why Mike Howard even did this. I think I only got another page. Let's see right here. The trial. Hold on. Let's see here. Let me blow this up. Let's see, because the investor wanted me to read this, so let me see here. The trial. Anthony trial began with a jury selection on June the 1st, 2026 in Collin County, with Judge Roach Jr. presiding. Jurors filled out the questionnaires. Oh, the jury pool was 600 people. So you mean to tell me in 600 people, Collins County couldn't find not one black person, which is another. You know what? I need to do a hold on. Hold on, my brain is starting to work. 1 second. Hold on. I need to see. Hold on, my brain just thought something. My brain. Hold on. One second. I need to see if the Bastion Rule Eagle document to get this case, what even the white lawyer said, the Bastion challenge. Let me see here. Let me see. I hope his new legal team listed in there about the 6th Amendment. Let's see here, jurors, because they pull a pool of 600 jurors. Okay. Black jurors. They pull 600. So they're not mentioning the jurors. Okay, hold on. 1. Okay, did they mention the Bastion Rule? Y'all, they didn't mention the Bastion Rule? I'm doing a search now on the actual grounds of the appeal, and they didn't mention the Bastion Rule? It's only one entry of jurors. Potential jurors. Okay, 6 potential jurors. So they were talking about jury misconduct. No overflow, no audio. Okay. And the jurors were sequestered overnight in a hotel. Okay. Okay, 12 entries. Okay, so let me do, okay, so now, hold on. Black jurors. It's something called the Bastion Rule that we talked about. Let me see if Karmelo Anthony, I'm not seeing the Bastion Rule pop up. They said that was a y'all, it's not showing up. I need to do some more digging. It's not in there, y'all. It's not in there. I don't see that in there. That should have been on the first rounds. I don't see that, but let's keep going. I don't see it in there, y'all, but I'm going to keep digging. It got to be in there. It has to be in there. So let's keep 100 people. During selection, the defense raised the Bastion Challenge, remember? I'm not seeing it in there. After the prosecutor struck 3 black female jurors from the pool, of whom the defense considered with similar situations to a white female juror that was not struck. So now that we know that it was a white female juror who also was an educator that was left in the jury pool, the prosecution argued that the 3 women were struck for race-neutral reasons, namely their status as a teacher of school-age children. Judge Roach sided with the prosecution and permitted the strikes. On June the 3rd, the jury was seated with no black jurors, though several people of color, including alternates. The jury was composed of 11 women and 7 men. 11 women and 7 men. On the seated jury was an educator who did not work in a traditional school environment. It don't matter. It don't matter. Let's keep going. It don't matter. Opening statements. Let's see what Bill. Hey, we wasn't in the courtroom, so let's go ahead and read this right here. Opening statements begin, and this is Wikipedia, okay? Opening statements begin on June the 4th, which is true, with Collins County District DA Bill Whiskey stating the killing was a provoked, unjustified, in which Anthony had provoked Metcaff to touch him. Now, this is the same prosecution in Mike Howard's affidavit that said that he knew that Austin was the primary aggressor. Anthony had provoked Metcaff to touch him, and that Metcaff pushed and shoved before Anthony in a sneak attack. He said, do y'all see that right there? A sneak attack with a concealed knife. Whiskey stated the case does not concern race or self-defense. The defense attorney, Mike Howard, stated there was various accounts of what occurred before the stabbing and that Anthony was seated when confronted by Metcaff and his brother's facts. Hunter. He stated it was Metcaff who made the first contact and that Anthony reacted in a split second of fear and chaos as the group was turning on him. Okay. Howard argued that Anthony was defending himself. Jurors were shown grainy surveillance camera footage of the incident where prosecutors said showed Metcalf pushing Anthony and then Anthony exiting the stabbing after stabbing Metcalf. A coach from Memorial High School then testified that it was unusual for a rival teammate, that's a lie, to be sitting in another school tent as Anthony was before Metcalf confronted him. Jurors also heard testimony from a coach from Liberty High School who viewed the aftermath of the stabbing as well as heard 911 emergency calls before following the stabbing and viewed Metcalf's blood-stained jacket. The defense asked Liberty High School coach if it was normal for students from different schools to converse and ask where athletes warming up would seek shelter. Okay, let's keep going. Let's keep going. Students were under the tent during the stabbing, testified on June the 5th. A student witness said that people, including Metcaff, had confronted Anthony and asked him to leave the tent, to which Anthony allegedly said, "Touch me and find out," and kept his hand in his book bag. That's all a lie, warning that he had something. Witnesses estimated Anthony would leave. Witness estimated Anthony was asked to leave as many as 15 times. We know that was a lie. The witness said they did not try to gang up on Anthony, and the exchange lasted about 2 minutes. Multiple students labeled Anthony the aggressor as he had entered the tent to escape the rain. The defense cross-examination focused on discrepancies between the student's testimony and the account they initially provided to law enforcement. Facts. They further established a physical difference between. Oh, listen here. Look. Did y'all see what Mike Howard did? At least Mike Howard did do this, according to Wikipedia. They further established the physical differences between Anthony and Metcalf, with the latter of being 50 to 60 pounds heavier, and emphasized Metcalf and other several people positioned over Anthony, who was seated. First responders, including a paramedic and a school research officer who arrested Anthony, gave testimony also. Go down to the next one. A police officer testified that carrying a 5-inch knife is unlawful in Texas, even though it was against school policy. The defense rests on June the 8th, with Anthony not being called to testify. The jury found Anthony a murder after 3 hours of a deliberation. A verdict was announced 1:35 p.m. on June the 9th. The jury rejected the sudden passion claim and sentenced him to 35 years in prison. Okay, I'm gonna hold my thoughts on that. On June the 10th, the day following the verdict and sentencing, Anthony was transferred to the custody of Texas Department of Criminal Justice and transported to the Wallace PAC unit in Navasota, Texas. He filed notice of appeal of his conviction. Under Texas law, Anthony is eligible for parole after serving his sentence of 17 and a half years. Reactions. Well, this right here, this next screen here, this just shows proof that a change would definitely be granted because of the Protect White Americans protest, right? Far-right activist Jack Lane and all of that, supporters outside of the courtroom. Gotcha. Let's see what else. Let me go and change this window right here. During his appearance on a podcast following the verdict, go down to the end of the page. Victim fathers referred to Anthony as, we already know that, a phase widely reviewed as invoking, you already know, in order to provoke a reaction and increase the visibility of the podcast. He also stated that he forgave Anthony for doing what he did, and he did not want to cover the hate and anger, which we know is a lie, and that he's not a R, stating that I care, but it was not. Hold on. Let me go to the comments. I thought it was gonna be a little bit more, let's just say, because he didn't do it, new trial, everything they said Karmelo said is hearsay, facts. They saw nothing but red as they were aimed on Kamelo butt, right? Nobody saw steal. Even Wikipedia didn't say that. Free Karmelo. 3 inches, not 5. That's what I'm saying. It wasn't even that long. It says 5 inches. Once Austin snatched Karmelo's Anthony book back. Nobody. Come on with it, Flo. Come on with it, Flo. As long as you don't touch me, we're cool. That's what I heard. They, of course, twisted it facts. It's crazy. Like you parents tell you eat my cupcake and see what happened is oh what? How could Karmelo keep his hand? Thank you, Flo. See, we on the same accord. I see y'all are taking notes. Karmelo said, as long as you don't touch me, we cool. I don't believe anything Austin said. I don't believe anything Austin had said. He could have 100 trials and still get found guilty because, oh gosh, because he would never meet the standard for self-defense. Okay, I see what your characters. I thought you was one of them trolls, but you're not. I got what you're saying. If the court proceedings in this trial was a nasty piece of work, they did not let Karmelo's grandparents in the courtroom to view and support their grandson. Yes, Bunny. We did not know if Kamelo really said that. That is true. No one provoked you to touch them. Contrary, hold on. Let me go and pull this back up. This is what Karmelo's Anthony lawyers did say what provocation was. For everybody that's coming in here, provocation is this. This is exactly what provocation is. Let's see. Where is that PDF again? Here we go. Provocation. All right, let's do a search. Let's see here. We know the real reason why he felt provoked. This is the most stupidest thing I ever heard, provoking somebody by telling them to touch me. And come on with it. Come on. Yes, the jury selection issues include the Bastion challenge arguments are included in the recent file paperwork. Okay, I'm looking for it. That's what I thought, Chandra. That's what I thought. Let's see here. Provocation. How did it provoke him? Thank you, Tony. You welcome. Let's see. It is in a Google search. Hey, I'm looking. I did not watch it all the way through. Remember the count women as minorities. He did a hold on. Who did an interview with DJ Vlad? Who did that right there? Who did an interview with DJ Vlad? Hold on, let me see him. He did an interview with DJ Vlad. You at the Boston Challenge? Oh, what you say? Sorry for bringing up. See, but he said he's still talking with the fan. It ain't about. I'm sorry. It's not you, Miss Jasper. It's not you. Trust me, it's not you. They should have 4K TV. Come on with it. Hold on. I know I read provocation in the document. Okay, here we go. Provocation, got it. Okay, I got 13 instances of it. Let's see right here. Relied on provocations, urging the jury to invoke the denial of the decline. Ooh. The error was harmful and requires a new trial. Let me share my screen. Let me share my screen. Let me share my screen. Trial. Let's see right here. Let me have it come up. Okay, here we go. The error was harmful and it was preserved. The defendant objected to the submission of the provocation instruction. The error preserved. Reversal is required upon showing of some harm. Almaza versus State 686. You see this right here of the entire charge. The state of evidence, the arguments of counsel, and any other relevant information. The harm here is plain. Self-defense was the central contested issue at trial, and the state did not let the erroneous instructions lie. In closing arguments, the prosecution firmly relied on the provocation instruction, urging the jury to invoke to deny the defendant his right of self-defense. An instruction was wrongly authorized the jury to set aside the defendant-only defense, and the state pressure is summarization, cause harm well beyond the some harm threshold, a new trial. Trial counsel affidavit establishes that the defense objected to provocation instructions. Okay, Mike Howard. Provocation instructions, and that the state relied on the instructions in closing. The defendant will supplement with the reporter's record when it is available. Exhibit 10. Let's see right here. In summary, the grounds of facts supported a new trial as the third grounds are the trial courts submitted a provocation instructed unsupported by the evidence, which improperly withdrew the law of self-defense. The defense solely contested defense from the jury's full consideration, and the error was both preserved and harmful. Okay. Let me get to what they said about provocation. I want to read to you about what they said in provocation in one of those evidence. Prayer. Whomever premises considered, the court restricted the general public to a 10-minute daily admissible window and provided no contemporaneous alternative for those foreseeable turned away without the founding Waller requirements. The resulting closure is structural error that a new trial is required to cure. Defendant Karmelo Cesare and Anthony therefore respectfully praise that the court set in motion for a evidential hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the party unrecorded agreement limiting character of evidence, and the repudiation and the preservation and harm facts concerning the unsupported avocation instructions may be developed. Grant the motion, set aside the judgment of conviction, and sentence. Order a new trial, conduct in a courtroom open to the public, enter written findings and facts and conclusions of law in support of his ruling. Grant the relief requested in the interest of justice, and grant such other future relief to the defendant may be justly entitled. Okay. Respectively submitted, Russell II. Lead counsel, we got Michael Ware, Gary Bledsoe, Brooke Claus, and Sean Deradia. Let's see here. Let me get to the provocation. was these the instructions? Yeah, those are the instructions. 1 hour and 33 minutes. Okay. Okay, hold on. Third round for a new trial. Let's see what it is. The court unsupported provocation instruction improperly limit the defense right of self-defense. Okay. Provoking the difficulty a defense away from the jury altogether, properly given. It tells the jury that a defendant who provoked the encounter forfeit the right of self-defense he otherwise enjoyed. For that reason, the Court of Criminal Appeals has had the instructions may be submitted only when the evidence support each of its three limits, and it gives it without the support is error. Okay. Here the instructions were given without the support, and it did to the defendant's self-defense case exactly what an unsupported provocation charge always do. It invites the jury to set the defense aside before weighing it. Okay. Let's see here. Let's see him. But I just want to show this also. I'm going to have to look for it. But I do want to show everybody that don't believe Austin. Metcaff. Let's go take a minute. Well, hold on, whoa. We only saw a handful of black people. Hold on. We got up to see for ourselves and found a room of people down the hallway out of what appeared to be a roughly 600 people. This is what, okay, we only saw a handful of black people. One of the officers from the room where we had been sitting came and told us not to come down there and that we needed to go back because he didn't want us to taint the jury pool. I responded that if that was a concern, I did not understand why White Lives Matter had been allowed to pass our propaganda about the case of people going in a paper using the wording Austin murderer, which I was concerned about already tainted the pool. We were sent back to the room where we were not permitted even to view the proceedings on a TV, and we were told that we would not see anything for no reason, and no one was going to notify the people sitting in there. We let the other people know, and most people left, deciding to return Wednesday or Thursday. Who was this? Who is this? Oh, this was the affidavit of Bridget Smith. Okay. Let me see what they got in here about Austin. Okay, that's the definition of murder, instructions of murder. I want to go to Mike Howard's. Mike Howard's. The defendant did not provoke Austin Metcaff, the person against whom the defendant used deadly force. The defendant was not engaged in criminal activity. Y'all bear with me. I want to show where we talked about this. Austin was the kind of like an aggressive guy on the team. He got triggered that Austin and Hunter, they were not going to let you see. Okay. He was the aggressor. Let's see here. The charge here gave some instructions. It directed the jury that if the defendant immediately before the difficulty did some act, use some language, or both with the intent to produce an occasion to bring on the difficulty and kill Austin, and that such conduct was reasonably calculated to or did provoke a difficulty to which Metcaff responded by attacking or appearing about to attack him, and the defendant then killed Austin Metcaff in pursuit of his original design. The jury would find against the defendant's claim in the instructions thus strip the defendant of self-defense. See, this is the issue with the instructions that the judge gave the jury. The instructions thus strip the defendant of self-defense upon a finding that he provoked Metcaff with a preformed intent and original design to kill him. Let's keep going. Let's keep going. It's the instructions. Judge Roach knew exactly what he did. Let's see here. I need to go to Mike Howard's 10. I'm gonna find it. Let me go back to the comments, because if you look at Mike Howard's, if you look directly in Mike Howard's Exhibit 10, he stated that the prosecution knew that Austin was the aggressor. Mike Howard thought he knew them, but they knew everything they needed to know about Mike Howard. If his license wasn't on the line, hold on. They were coming for him. He would not have submitted the affidavit. Okay, facts. So provocation by defense means no self-defense just cause the prosecution said, so come on with it. He didn't approve nothing with his opinion. Karmelo Anthony repeatedly said, don't put hands on me. If you touch me, you'll find out. Warned by Karmelo, boundaries were, yes, established. The reason why they didn't bring the weapon as evidence because no fingerprint. Thank you. Yes, Bunny, they twisted the uses of provocation in the witness's testimony. Do you see they gave and their own opinion about what provocation was versus the defense? What it actually, the definition of provocation. If Karmelo didn't testify, how can they say he did? Because you're right, Trisha. You're right. Violation, Sixth Amendment, prosecution misconduct, and RICO. Come on with it. Is that why we heard earlier on Karmelo provoked Austin to put hands on? Yes, Bunny, because they knew how they was going to spin it exactly. If you don't have epilepsy, being Mike Howard said that no epilepsy couldn't be brought up. No neuropsychological expert could be brought to the court because they didn't even want epilepsy mentioned. He feared for his life because python-sized biceps was choking him and he has epilepsy. Show us the redacted video so we can all see what occurred clearly and not rely on what the prosecution alleged. If they had a clear video of provoking attack, you would have seen it. Well, let's see what's going on. Means to heed a warning. Yes, it does. In the trial, they twisted the way provocation should be. Come on with it. Come on with it. What you say? Even if he did literally think he was going to get jumped, it wouldn't be the... That's a lie. That's a lie. Listen, go to Texas, a multi-assailant doctrine. That is a Texas own lie, multi-assailant doctrine 3:1800. They don't have your hands on you. As long as you feel for your life, you got all right to meet deadly force with deadly force. That's not true. That's not true. Let's see here. So Did Karmelo Anthony have some bruises on his body after being jumped? Yes. Yes, he did. They doctored up the arrest record, the arrest picture. Yes, they did. Yes, they. Hold on. I don't know. You can't even see it. But yes, they did. They doctored up his arrest record. I hope I still got that picture in here. Yes, he did. His face was toe up. His face was toe up, and they doctored the original arrest. What picture is it? Hold on. Go to the arrest record. I took it out the slide deck. But yes, if you go to the undoctored arrest record, even though it's black and white, you can see this side of his face is gone. Hold on, Chucky was in here. Chucky was Chucky was in here. Oh gosh, Chucky was in here, y'all. How did y'all into Chucky? Listen. Provocation is when a person being warned ignores the warning. I want to find that. Autopsy is one of their secrets. Listen, and they didn't even bring it to church. I'm gonna say they didn't even bring it to court. Nor the Chucky was in here. They didn't even bring the toxicology to the court. Them boys was on it last night. Kamelo shouldn't have spent not one day lockdown. That's right. Oh gosh. Oh, are you sitting? Yeah, I'm definitely not gonna watch CW on Vlad. No. I'm going with what the white elderly lady said. He failed on the tube. The parents taught Austin all the hate. Come on, what's up, Bad Bunny TV? They considered the 7 women the minorities over the right. They went black. Hold on, I'm not gonna let this go. Hold on, y'all. Let me go to Exhibit 10 because Mike Howard said that even the prosecutor. Listen. I'm gonna find this. I'm just got to clip out the space, but I'm gonna find this because Mike Howard said that even the prosecutor knew that Austin was the aggressor. Ambiguous. I gotta find this. Ambiguous aggressor rule. Come on with me. Come on with it. Let me show you. And then I'm gonna let y'all go. I'm not. Nah. I want to show y'all this just in case y'all missed. Come on, Wendell. Here we go. Let's see here. All right. So. So this is just the agreement that they wouldn't bring up all of the things about the Metcaff twins as well as racism. In exchange, the prosecution would not go into character, reputation, and extraneous offenses acts evidence related to Karmelo Anthony. Like the no guilty boy said, I want to know what evidence they said they had on Karmelo that included and exclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. Okay. Specifically how to handle the possibility to open the door. We done talked about that. If I skip over it, I'm gonna go slow because I want to highlight this for everybody. Look at this right here. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about fight or flight responses, they consider expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense and violence. Let me tell you. Okay, this already. Here, where it said about Austin as the aggressor, John Roach. See, even during this is the legal agreement that John Roach knew about. During this meeting, both sides explained the agreement to the judge, describing it again as both sides agreed to not go into character representation. So Judge Roach knew about this illegal agreement. The defendants. And let's see right here. What happened under the tent? Even the judge, he said, you only gonna talk about what happened under the tent. Okay, students outside. Number nine. Let's see here. I voiced my concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify was unavailable Saturday, June the 6th. We talked about that. One of those witnesses did not come. Let's see right here. Whiskey. They want to call Anthony out of order. So number 11. Let's keep going. I'm getting close to it because now they're starting to talk about the aggressor, the ambiguous aggressor rule. Number 12. Mr. Whiskey was aware that at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense for presenting damaging character and reputation evidence against Austin and Hannah Metcaff. Why are both of the twins mentioned in this right here? Why are both of the twins mentioned in this right here? If Hannah didn't have nothing to do with this. Let's see him. Okay. Austin's a really big guy. So we talked about that. That was number 14. Okay, Metcaff twins arrest for racial graffiti. Okay, number 16, no experts for Karmelo and Anthony. Number 17. Number 18. Here we go. Other than general character testimony and plea for mercy, in reliance to the agreement, the defense also did not go into substantial. We talked about 18, y'all. Y'all go read 18 on your own, okay? Go ahead and read 18 on your own. Read paragraph 18 on your own. Mike Howard's affidavit number 10. Okay. I wonder, who is this witness that they blotted out? The defense plan next witness had been avoiding defense subpoena and kept changing the time he told us, so it was a male. He told us that he would be arriving to the courthouse. According to Mr. Lacey's testimony, we took a break. Okay, let's keep going. Let's keep going. Okay, that's number 20. '21, 22. 23. Here it is, paragraph number 23. Paragraph number 23. It says, furthermore, Mr. Whiskey stated that at this time, the prosecution already had rested character, reputation, and extraneous evidence pertaining to Austin and Hannah Metcaff was not relevant. At the bottom of number 23, when Mr. Shook and I mentioned the ambiguous aggressive rule from Torres, Mr. Whiskey argued that Torres did not apply because it was not ambiguous who the first aggressor was. The first aggressor was clearly Austin Metcaff. At this point, the discussion devolved into a shouting match. Number 23, anytime that y'all, in any platform y'all go to, and you got a troll in there saying that Karmelo started this whole entire series of events, you go to Mike Howard's Exhibit 10, paragraph 23, where Mr. Wilkie, it said, Mr. Shook and I mentioned and the ambiguous aggressive rule from Torres. Mr. Whiskey argued that the Torres did not apply because it was not ambiguous who the first aggressor was. The first aggressor was clearly Austin Metcaff. Where is Jeff Metcaff at? I bet he messing up his pants. Now, also in here, it talked about provocation. It talked about provocation, then I'm gonna let you go. I hope it's not in another exhibit, but paragraph 23. Paragraph 23. Paragraph 23. And also, I think Hyatt, it said that they didn't want to introduce the knife. Paragraph 23. Man, y'all, this right here just shows proof that they violate this young man's constitutional rights. Look at paragraph number 27. They talking about the Fifth Amendment, and also explained that if he testified, Judge Roach believed he has no mechanism to enforce the agreement between the parties and will rule on the rules of evidence alone as to whether the door is open. Hold on. What is the rules of evidence? And then I'm going to let y'all go. What is the rules of evidence? Rules of evidence. Rules of evidence. Texas rules of evidence. Okay, just an overview. The Texas rules of evidence governs the admissibility of evidence and testimony in all of Texas state courts. To be admissible, evidence must be relevant, authentic, material, and not subject to exclusionary rules or privileges. Article 1, Article 4, Article 5, Article 6 and 7. Article 8 deals with hearsay. Okay. And Article 9 and 10 deals with authentication and contents. I think we talked about that. So that right there. Now let's see here. Okay, so Mike Howard was not. So yeah, we got some more digging to do. I'm gonna go to the comments. I'm gonna let y'all go, but we got some more digging to do. Let's see. Let me go down here. We got some more digging to do. The evidence was not authentic. Come on with it, which violates Judge Roach's own rules. Rules of evidence. Come on, Flo. I didn't want to mention that, but I see you mention that. Eddie and Hunter to the stand. Come on with it. And Judge Roach. Jeff said he was going to Europe on vacation. Now he wants to come back. The man kept a linebacker on their team. I think the two was meant for Kamelo. How could do y'all remember in my last video I asked the question, was Hunter left-handed or right-handed? Y'all, I got so many responses. They said that Hunter was left-handed. And if you're left-handed and you're swinging, right? Because they said Hunter, multiple people said they saw Hunter when he went up to grab the diploma for himself and his brother. I forgot what it's called, postmoderus. It's a long P word. That he grabbed the diploma with his left hand. So I can see that if you're swinging with your left hand, it does swing out in an angle. Y'all, Hunter did that, y'all. Hunter did that. Hunter accidentally caught his brother with that knife, intentionally or unintentionally. I believe since all eyes are on Collins County, they don't want us any more heat because it's national news. It's too late. It's too late, Carol. Hunter was the blotted out. So why? If Hunter's name is throughout this whole entire, especially Mike Howard's exhibit, and throughout the, it was part of the gentleman agreement, Hunter's name was listed in the agreement. So why blot it out? What's blotted out? Hunter's name was blotted out, but his name was listed in the whole entire other. Okay. The black coach who called the twins to set up the He was black. So he was the coach. So he was the coach that brought them in, even though they were suspended. Oh man, I didn't know he was black. Because he needed heavy weights to could lift the tent. Oh gosh. So he liable too. He's liable too. Two heavyweights charged Karmelo Anthony, and one of them got him in the head like Kamelo was outnumbered and outweighed by each boy landing blows. Ooh, yeah. They wanted his lawyers to see but not reveal. Come on with it. Jurors probably in high. Guess what? Judge John Roach also got the jury list sealed too. Now choked off, hold of a heavyweight bicep that could trigger. Yes. Where are the jurors? In hiding. Python side biceps. It was 11 women inside of a man. Yes. Where are the middle-aged people trying to rule? Hey, how you doing, Protected? How you doing? It looking at the double dose of Metcaff standing over him. Mike Howard wrote it all up. Channel 4 doctored up his photo. Right. They photoshopped all his bruises, and in the picture, you still can see a portion of this dredge pulled out. And if you look at this part of his face, you can definitely see it swollen. When you see Karmelo immediately after the incident, audio recordings of Karmelo telling us, "I told him not to put his hands on me." Why haven't we heard? They sealed. They name identity is sealed. Channel 4 hair was pulled out. That wasn't Karmelo Anthony knife, and that baby didn't do it to Austin. Yes, was something else. Yeah. Yes, I agree with you. They need to tear the system down in Texas. Facts. When the police put handcuffs on Karmelo, there were blood on his fingers. Where did the blood come from? I think it's when he fell. Because they didn't even bring the blood up in court that it was Austin's blood, so it was on his own blood. I think it came from when he fell down and ran. Karmelo didn't testify yet on the video. They told him not to put his hands on me. Yep. The judge is holding the sealed document in his chambers. You're right. Shahara. And if they wanted to view, they had to go to the right. And let me tell you one thing. The new legal team say, no, if I see the documents, I'll have the right to share whatever the contents are to whoever I feel. Judge Roach says no. Who is Judge Roach? I answered that question. I asked that question at the beginning of this live. Who does Judge Roach think he is? Free Karmelo. Hey, how you doing, Richard? Free Karmelo. Don't forget this. Paragraph 23. When Mr. Shook and I mentioned the ambiguous aggressive rule from Torres, Mr. Wiki argued that Torres did not apply because it was not ambiguous who the first to the last. The first aggressor was clearly Austin Metcaff. Let me go ahead and pull up this right here. I want to see this right here. And then I'm going to let y'all go. I'm going to let y'all go. I want to do some more homework. What is Torres Sanchez? No. Torres, the ambiguous aggressor. Here we go. Torres versus State, 2003, Texas Court of Criminal Appeals decision. Oh, okay. Hold on. Hostile interpretation of ambiguous cues. Individuals with high trait aggression or a history of trauma often struggle to objectively read subtle or undefined social signals. Instead of seeing a neutral expression or unintended bump, they jump to conclusions and interpret the situation as a personal threat or insult acted out defensively and proactively. Okay. In a psychological studies, researchers use ambiguous aggression takes, morphed facial expressions shifting from neutral to anger, or scenarios with unknown intent to measure the subject's reflex, perceptual sensitivity, and judgment towards perceived hostility. Studies note that physical aggression people often spot anger in ambiguous situations with superior speed. So who are they talking about that to? Yeah, I got some more digging to do. I got some more digging to do regarding Torres versus State. Okay, let me go ahead and finish reading these right here. I said Hunter did it a long time ago, allegedly. Hunter wouldn't come in or take the stand. I don't even know how John Roach allowed, well, now I do, to even ignore the subpoena. Frisco corruption. How did Karmelo get blood on his fingers when he was arrested? Right, but Hunter hid in the back of the courtroom to listen to the trial illegally too. The coach was liable. He tried to blame Karmelo Anthony because he was supposed to be underneath tent at all times. On the news with his mother, Hunter said that he asked Karmelo to leave, and Austin always backed him up. Facts. Even the picture you had up dreads missing. It was so strange that no point in time did we see a front of you. Oh, hey, that's a good observation. It was strange that at no point in the time we see the front of view of Karmelo on body camera from the police because they were supposed to document any injuries. God darn it, yes. What did you say? Watch too much. No, you good. Because you're right. But you know what they did? They spliced it out. They spliced it up because they hid his injuries in his arrest photo. So they had to splice out his picture. They had to splice it out. That black coach had suspended the twins from the team. However, being short of staff, he needed big boys to help set up those heavy he is liable. Not sure if Metcaff got arrested for racist graffiti due to the coach suspension or not. Gotcha. I think they were trying to say Karmelo saw abuse. One of these coaches was fired from Urban Independent School District for having an altercation with a parent and a student. Okay. Who is Valerie Perez? Eddie Perez, they related or friends? I'm hearing that. Yes, I'm hearing that is the case, Zane D. Frisco ID becomes liable because the adult was absent and a life was lost. Yes. So, and Karmelo Anthony, okay, yeah, Eddie played cousin, Zane, yeah. Karmelo Anthony family can also sue Frisco ISD because of that situation where Karmelo Anthony had to defend himself. But don't forget, please don't forget 23, paragraph 23, where, and I got what you said, Vesta. Let me see here, Vesta. I know exactly what you were saying. Vesta, you know who you are. I'm trying to find it, but I guess they was trying to say that too. But okay. But Mr. Wiki argued that Torres did not apply because it was not ambiguous who was the first aggressor. The first aggressor was clearly Austin Metcaff. But I got what you're saying. All right, Vesta, it's been 2 hours and 8 minutes. I'm not going to hold you any longer. I got to make some calls and aggravate. I need to call somebody and aggravate somebody. I got it written down. Listen, she said I got it written down. And also, let me go ahead for this paragraph 6, 5, and 6, the Karmelo's Anthony about his parents. Here you go. Paragraph number 6, I would never end. That's where go to the bottom. After the defense asks about how the Anthony family members testifying at sentencing, Mr. Wiki agreed that the agreement would cover no, so don't forget paragraph number 6, okay? Come back up here. Let me share it again. Paragraph 6. Paragraph 6. Okay, paragraph 6. The last two sentences. After the defense asked about that the agreement would cover Mr. Anthony's mother's testifying to the standard, I love my son, please show him mercy type testimony, but no further. Paragraph number 6. And number 5, that talks about kicking in the door and the agreement, okay? But the knife was up in here too. The knife was up in here, where they agreed not to bring the knife to court. But I get back with you tomorrow on that. But yeah, they didn't want the knife to be brought into court. So that's it, Vestas. Let me end with this. Tony, was the actual weapon ever presented in the document? No. It was not even in the appeal, and it said that it was agreed upon that it would not even be introduced. Let me see here. Weapon. It shouldn't be. Matter of fact, the weapon wasn't even really talked about, minus the length, right? The weapon wasn't even really talked about. Deadly weapon, okay, that's instruction, term definition. It wasn't even talked about. The weapon was not even talked about. It said nothing. No. All right, Mel. I should have told you earlier, I was always a poet myself. Patrick Green. Kamelo's face is proof of him being headlocked under the tent of the ceiling. Hello, ToneyTalksVestedUp. Hey, how you doing? Hey, how you doing, Ari? What? What happened? I'm gonna wait on your. Okay, here we go. From what I've seen, they shown a replica of the so-called knife. That is true. No, under the right arm. Yeah. All right, Buster. So it's after 10 o'clock here. I gotta, like I said, I gotta call and aggravate some folks on the. But paragraph number 5, number 6, and number 23, and number 23. So until next time, what you said, let's move on to the real victim. Who is the real victim? Karmelo Anthony. We're talking about the real victim. We are talking about the real victim, George. I'm trolling. We're talking about the real victim. We're talking about Karmelo Anthony, who his own defense lawyer has confessed it, that they set this young man up and they took away all of his constitutional rights and civil rights. We are talking about the real victim. So perfect timing. Perfect timing, perfect timing. You're welcome, Flo. You're welcome, Justine. Thank you, Ari. We are talking about the real victim, Karmelo Sincere Anthony. 3.7 GPA, 21 scholarships, saved a young boy's life before this incident here, had 2 jobs, was a very loving son and young man. So we're talking about Karmelo Anthony. So Vesters, until next time, make sure you're going to get your notes, your drink, and your vest, because we stay vested up over here 365 degrees at Tony Talks Vested Up, compelling sports edge. Rico, darn it. Come on with it. All right, Vesters.
The multiple assailant law, that is considered a deadly weapon. So that means that Karmelo Anthony, he meant deadly force with deadly force. It being circled with 4 people. 2 people together was almost 500 pounds, 440. That means he meant deadly force with deadly force. If they could have had their way with Karmelo Anthony, we would be singing a different tune. Definition of defense of property. Since Hunter just said that Austin grabbed his property before the fight took place, that means that those boys was aggressive. This young man is sitting up in the bleachers minding his own business. Let me paint the stage since Mike Howard didn't do it for the jury. He's sitting up there invited under the tent. And Tony Talks Vested Up. How you know they coming with aggression? Because we saw how they was walking up to them stands. And they went up in them stands. And Hunter just told exactly what happened. He said, we walked up to him and told him to move. Aggression. He still didn't do nothing. They tell him to move. All these multiple people, 150, 220, 220, maybe 150, 150. Ooh, it's hot. It's hot under that tent. You don't know what's going on. The original people that saw the video, it said it happened in a matter of seconds. Fast, sufficient evidence. The prosecutor has a burden of proving every element of the defense beyond reasonable doubt. If it cannot do so, the defendant is entitled to an acquittal. The prosecution has the burden of proving every element of offense beyond a reasonable doubt. If you can't do so, it said every element, the defendant is entitled to an acquittal. What did Hunter say? Didn't Hunter say, we went up to him? Oh, Hunter. Oh, Mike Howard. Oh, Prosecutor Greg Willis. Oh, Judge Roach. Oh, Texas AG Ken Paxton. Multiple assailants. That they don't think that he should have took those measures to protect his life with the weight of a middle schooler. So for everybody that's painting that Karmelo Anthony reached around in his bag and got the weapon, tell Hunter that, because Hunter just said that Austin took his bag. They want us to believe that Karmelo Anthony threw away his future for Austin Metcaff. With this 3.7 GPA, graduating the next month, no disciplinary action, captain of the football, captain of the track, and 21 scholarships. Get out of here.